Welcome to our lecture. Welcome. Today's lecture, of course, is about avoiding conflicts of interest regarding the law firm and its current clients. You remember me. I am Patrick McGinley. I am your friendly neighborhood bar grievance defense attorney, by which I mean that I enjoy defending my fellow members of the Florida Bar or District of Columbia Bar against bar grievances, ethics complaints. I assist when ethics issues arise, and I make sure that my fellow lawyers stay out of trouble. And for those of my fellow lawyers who have fallen into trouble, it's my job to get them right back up and out again. It's great work. I highly recommend it. And it is from that perspective that I present to you today's lecture regarding conflicts of interest. Of course, a conflict of interest, regardless of what profession we're in, is something we want to avoid. That's true, of course, for lawyers too. Lawyers want to avoid conflicts of interest. The rules regulating the Florida Bar, of which I'm a member, and the DC Bar Rules of Professional Conduct, again, which I'm a member, both have prohibitions against conflicts of interest, and both have ways in which a conflict of interest can be acknowledged and can be waived if the waiver is done correctly. So we'll be covering those concepts, not only from the perspective of the bars of which I am a member, but with general purpose. And specifically, we'll be looking at some of the concepts we find under the model rules of professional conduct. Why avoid a conflict of interest? Well, obviously, every lawyer wants to be on the up and up, wants to be wholly ethical. We want to avoid a conflict of interest that can't be waived simply as a matter of ethics, but also conflicts of interest have repercussions. For example, there are times when a conflict of interest arises later in the representation, which results, unfortunately, in the lawyer having to abandon all clients. That can be unfortunate, not only for the clients, but for the lawyer. Likewise, a lawyer who's operating under a conflict of interest can be accused of being unethical and therefore might be subject to losing payment, losing entitlement to attorney fee, perhaps even having to disgorge or give back past earned fees if it can be alleged and proven that those fees were earned in violation of the rules of professional conduct. And a conflict of interest can be one such violation. So when it comes to our reputations, when it comes to our ethics, when it comes to our wallets, we have to avoid conflicts of interest, and we have to take care of them in those unavoidable situations where they arise. So that's why we're looking at conflicts of interest today. And when it comes to the ABA model rules of professional conduct, those same rules that you would be tested upon if you were to take the MPRE, the Multi-State Professional Responsibility Examination, those rules are plentiful. There's so many under Chapter 1, the lawyer-client relationship, that address these conflict of interest rules. For example, Rule 1.7, that's going to be our main focus today, the concepts taken from Rule 1.7. Rule 1.7 has been enacted in some shape or form in every U.S. jurisdiction. In very many U.S. jurisdictions, the wording has been improved upon because the model rule wording certainly needs improvement. But Rule 1.7 talks about a conflict of interest with current clients. Rule 1.8 talks about a conflict of interest with current clients again, but it spells out some very specific rules, specific instances that we have to look out for and we have to deal with exactly as spelled out in Rule 1.8. Rule 1.9 talks about conflicts of interest with regard to former clients. Rule 1.10 talks about the imputation of conflict of interest. Rule 1.10 under the model rules is the general rule for when a conflict is imputed to other members of the law firm. Rule 1.11 talks about special conflicts of interests for former and current government officials and former and current government employees. That's Model Rule 1.11. And then Model Rule 1.13 talks about the organization as a client, and in so doing helps us understand when a conflict of interest can arise. So that's a rather long laundry list, is it not, of rules and specifics that talk about a conflict of interest. We're going to break it down. We're going to talk about them one by one. But when it comes to this particular unit of our lecture, we're going to be focused mostly upon Rule 1.7. Now, regardless of which rule we're looking at on that long list, in my humble opinion, there are 4 basic principles at play. These basic principles and how they turn out under your particular facts help to determine whether or not, first of all, there's a conflict of interest, and then whether that conflict of interest can be avoided or waived. So those 4 basic principles are such. First, the lawyer is one-sided. One-sided. A lawyer's job is advocacy, whether that's litigation advocacy, whether that's advocacy in a transaction. Typically, a lawyer is one-sided. Can a lawyer be multi-sided? Can a lawyer be a neutral? Yes, but then the lawyer is serving as a third-party neutral, as an arbitrator, as a mediator, as something that is not pure lawyering. When it comes to pure lawyering, a lawyer is one-sided. The second of the 4 basic principles I point out is that lawyers are independent. Our rules of professional conduct, both under the model rules and as enacted in every jurisdiction, respect the fact that a lawyer has an independent judgment and preserves the independent judgment of the lawyer. So we see here sometimes where a waiver can't be done because the independent judgment can't be maintained. So that is one of the 4 core principles we see at play in these rules when it comes to conflicts of interest. The third of the 4 principles is that a client's situation can change. A client's situation can change. Here in the context of a conflict of interest, that comes up quite often when there's a potential conflict at the onset. Perhaps all the clients are in unison. They're all in agreement. They have no disputes in the beginning, but the joint clients have the potential for a dispute. A conflict of interest can arise later. The client situation can change. And the fourth of the 4 basic principles that I like to identify is that more than one client can share a lawyer. A wise man, in my opinion, the wisest man, once said that a man cannot serve 2 masters. He either loves the one and hates the other. Putting aside that biblical truth for just a moment, it is also a reality that our rules of professional conduct, no matter where enacted, say that a lawyer can represent 2 or more clients in the same lawsuit or transaction. But that situation can yield conflicts of interest now or later. And other issues can arise when one lawyer has more than one client in the same lawsuit or transaction. So that is one of the 4 basic principles that come into play when it comes to whether or not there's a conflict and when it comes to whether or not that conflict can be waived. So these are 4 basic principles. Now, with the basic principles in mind, let's look at some specifics. As I promised, let's look with great specificity at the concepts that we find arising under Model Rule 1.7. In most jurisdictions, it retains the number 1.7. I know for you Texans watching, it has become your Rule 1.6. Here in Florida, the rules regulating the Florida bar becomes 4-1.7. And the DC rules of professionalism, 1.7 is retained. But these concepts that I'm going to cover here come directly from the model rule. And these concepts, words can change, but these concepts remain consistent throughout the majority of U.S. jurisdictions. So whether you're studying for the MPRE or you're putting this into practice, these are the concepts you need to know. When I put up a slide later that claims to be quoting ABA Model Rule 1.7, please know that I did not, I repeat, I did not quote it verbatim. This is for the main purpose of the fact that the language in Model Rule 1.7 is rather inartful. I apologize if I've offended any of the drafters who worked hard on those model rules, but the inartfulness is there. I think that's why you see, for example, Texas, for example, DC, spelling out in better specificity the language that used to appear in the model rule. So I too am going to paraphrase the model rule, but in so doing, I maintain and retain all of the important concepts. So let's take a look then at model rule 1.7. As paraphrased, it says that without a waiver, a lawyer shall not represent a client when, rule 1 of 2, representing one client is directly adverse to another client. Or, number 2, there is a significant risk that the lawyer will be materially limited by the lawyer's responsibilities to another client, to a former client, to a third person, or to a personal interest of the lawyer. And note, very importantly, the word or, either or, without a waiver, either or, these situations creates a conflict of interest. To help us better understand these concepts, we should take a close look at the model rule definition of some of these terms. For example, in the first of the two alternatives, that one being representing a client that is directly adverse to another client, we do have some guidance from the official comments of the model rule 1.7 as to a proper definition of directly adverse. Now, the model rules have a rule 1.0 that contains a list of definitions, but under rule 1.0, we don't have a definition for directly adverse. So I extrapolate the following definitions from the official comments to model rule 1.7. And I think these are a fair extrapolation. To define that phrase, directly adverse, we should do so somewhat differently in the context of litigation versus the context of transactional work. Turning first to the context of litigation, the phrase directly adverse, as used in the model rules, can be defined to mean advocating against. Advocating against. And I use that in a broad sense. Of course, that includes suing, bringing a claim against someone. But advocating against here means more than just suing. For example, you might not be suing, but you might be cross-examining in one suit a witness who is a client of yours in another suit or transaction. That would be directly adverse, even though technically you're not suing that witness. Maybe you're not actually cross-examining, but perhaps you are causing damage to, or you are damaging without suing. That too would be an example of directly adverse when it comes to advocating against, when it comes to litigation. So, what's excluded? We can tell from the official comments that something that is economically adverse is excluded from the model rules definition of directly adverse. What do I mean by that? Well, just because your actions might be in economic adversity to a current client, that does not mean that your actions are directly adverse. For example, competing bids. Imagine, if you will, that you're submitting a bid for one client, but you've also submitted a bid for another. In a true economic sense, that is adversity. But when it comes to the definition of directly adverse as used in Model Rule 1.7, it would not meet the definition of directly adverse. So that is a working definition that we extrapolate for directly adverse in Model Rule 1.7 in the context of litigation. But as I mentioned, we should take a look separately at the context of transactional work. In transactional work, we can define directly adverse as used in Model Rule 1.7 as meaning negotiating for. Negotiating for. So, for example, that would include both negotiating for within this transaction and negotiating for in other transactions. So, different transactions. For example, perhaps you're negotiating for the buyer now, but you're negotiating for the seller later. If on the other side of that negotiation you see a current client, even though it's a different negotiation, that will meet the Model Rule 1.7 definition of directly adverse. So watch out for that. That's a little bit different, isn't it, than we see in the litigation context. That's why I broke it down and separated out litigation versus transactional work. But there is an overlap when it comes to what's excluded. Yet again, for transactional work, something that is just economically adverse is excluded from the definition of directly adverse. For example, again, separate offers. Perhaps a government agency is buying lots and lots and lots of apples. You might represent one client who can fulfill maybe 20,000 of that potential million apple purchase, and another client who can fulfill 16,000 of that potential million apple purchase. In theory, they are competing with those offers to sell those apples, but you can represent both and make separate offers without meeting the Model Rule 1.7 definition of directly adverse, at least not in the transactional work context. So I break it down because it's important. The facts, of course, are the deciding factors, and run those facts through those 4 principles that I gave you to begin. The first principle being that lawyers are one-sided. The second, that lawyers are independent. Third, that a client's situation can change. And fourth, that more than one client can share a lawyer. But there's a definition of directly adverse, as you'll see it in Model Rule 1.7, as they use it in subsection A, subsection 1. But remember, this is an or situation. So we can't stop just by looking at subsection 1. We've also got to look at subsection 2 and take a look at some of the terms that require a definition there. I'd like to highlight for you the phrase materially limited. What is meant by Model Rule 1.7, subsection A, subsection 2, when it says that there's a conflict of interest, when there's a significant risk that the lawyer will be materially limited by the lawyer's responsibilities? What is the definition of materially limited? To define that term, I offer you the following. Materially limited means that it interferes with a lawyer's independent judgment. If it interferes with the lawyer's independent judgment, then it is materially limited. So what would that include? Well, it would include, for example, being unable to take an appropriate course of action. A lawyer, in the lawyer's best judgment, should be able to determine the appropriate course of action. But if the lawyer can't take the appropriate course of action because something has interfered with the lawyer's independent judgment, then that meets the definition of materially limited. What's excluded from the definition? It excludes the mere possibility of subsequent harm. Remember, sometimes, especially in the situation of a joint representation where more than one client shares a lawyer, there might be unison now, but the potential for strife later. The mere possibility of subsequent harm does not mean that the lawyer is materially limited, at least not insofar as that term is used in Model Rule 1.7. Something to note, a positional conflict. What do I mean by a positional conflict? I mean that sometimes, in one case for one client, you might take a position, for example, that the law should be interpreted to mean X, not Y. Then perhaps in a different case for a different client, that same law, you might take the position, means Y, not X. So there you are, the one and only lawyer, with the one and only law. But in case A, you're arguing that it means X, not Y. And in case B, you're arguing that it means Y, not X. That is what I mean by a positional conflict. You're taking a position for one client in one case as to the meaning of a law. That is the opposite of the position you take in another case for another client. That's a positional conflict. Does a positional conflict mean that there's a conflict of interest? And here is the general rule. Lawyers are allowed to take inconsistent legal positions. Yes, they are. They can do so in different courts, and they can do so at different times. But the rules are violated if the lawyer's argument in one case will, note that I bolded that word, will adversely affect a client's outcome in another case. So this is one of those situations that you might put under that third of my 4 basic principles about how a client's situation can change. For example, you might be arguing in the same circuit court. We call our trial courts here in Florida circuit courts. You might be arguing the same Florida State Circuit Court in front of the judge that the law means X, not Y. And then in a separate case, in the same Florida Circuit Court, arguing that the same law means Y, not X. And that can be okay unless somebody in one of those 2 cases marches forward to the appellate court, in which case the appellate court might make a definitive ruling binding upon both cases as case law precedent as to what that one statute means. At that point, the rules can be violated because now you might be heading toward will. I hope my example helps to clarify when a positional conflict becomes a conflict of interest that you must act upon, instead of just a potential conflict that need not require your action at this point. The dividing line is the will. I hope that clarifies the fact that you can take inconsistent legal positions in different courts at different times, but that can lead to a conflict later that you'll have to resolve, most likely through withdrawal. Another note to point out about these conflicts of interest: the source of the material limitation. Where can the material limitation come from? If the lawyer is materially limited, what caused it? What do I have to look out for? First, of course, the source might be another client. Also, the source could be a former client. Former clients and the duties of loyalty that remains, the duties of confidentiality that remains, can cause a material limitation. A third source could be a third person, neither a client, were they ever, neither now nor never. They're simply a third party. They were never a client. But yet, that third person, such as a potential client, such as a family member, might cause a material limitation. And the fourth situation acknowledged in Model Rule 1.7 as a source of a material limitation would be the personal interest of a lawyer. Now, that could be your own personal financial interest. That could be your own personal spousal or loved one or family member or friendship interest. That could be a business interest of yours. The personal interest of the lawyer can lead to a material misrepresentation. Some more examples that might help. Another example of a third person could be a fiduciary. Perhaps you owe a duty, or perhaps you are a trustee. Perhaps you owe a duty to a corporation. You're on the board of directors, or family members on the board of directors. An example of a personal interest of the lawyer. What about a self-referral? For example, maybe you own a court reporting company. It could be a conflict of interest that might materially limit you, perhaps, if you felt the desire as a litigator to make sure the court reporter for every deposition and hearing and trial is always your own court reporting company. This could arise perhaps in a transactional case. What if you own the title company? Perhaps you always want your title company involved in your lawyer real estate closings. I'm not saying that you're always forbidden from doing this, but I'm saying that a material limitation can arise from such a situation. Watch out for and avoid such a material limitation. Another example that could arise, the personal interest of a lawyer that could cause a material representation, family, whether by marriage or blood or love. The interest of a family member could become so entwined with our own interests that it could become a source of a material limitation. I almost said misrepresentation. Gosh, that's a whole nother topic. No misrepresentations, fellow lawyers. Got to avoid those, of course. But today's topic that we're trying to avoid are impermissible and unwaivable conflicts of interest. So let's focus on conflicts of interest. So those are the 4 sources noted in Model Rule 1.7 from which a material limitation can arise. Another client, the former client, the third person, the personal interest of the lawyer. Now, of course, what we've been talking about here is where a lawyer shall not represent a client without a waiver. Remember that? I highlighted for you again. Without a waiver, these things cannot be done. Without a waiver. Can you have a waiver for 80% or more of this? The answer could be yes. Perhaps you could have a waiver. Let's take a look at whether or not you could have a waiver. When can you have a waiver? How can you have a waiver? That is our inquiry next. And we borrow these concepts through paraphrase from Model Rule 1.7 and from the official comments of Model Rule 1.7. Waiver must be available and must be done correctly in order for waiver to be sufficient to avoid the negative repercussions of a conflict of interest and allow you to continue your representation despite that conflict of interest having arisen, or avoid potential for that conflict of interest. So the waiver isn't always available. Sometimes it can't be waived. And even when available, if you didn't do the waiver correctly, then the waiver's not going to allow you to overcome the conflict of interest. So we're going to have to break availability and done correctly down separately. Let's look first at available. When is the waiver available? Here's the one lengthy and meaty sentence that sums that up. If neither litigating a claim against the client nor prohibited by law, and the lawyer has a reasonable belief that she'll be competent and diligent despite the conflict. That's when the waiver is available. Note the first part. When you're litigating a claim against the client. Now, when we define the terms, I noted that a conflict can arise when there's adversity shy of actually litigating a claim against the client. Remember, one of the examples I had for you was cross-examining a client. The other example I had for you was damaging behavior that was damaging to a client. But the ultimate act of actually litigating a claim against the client, whether it's in an administrative tribunal or a true court or in a claim, if you're actually litigating against the client, that's not a situation where waiver is available. It's simply not available. And I would fault the language of Model Rule 1.7 for phrasing things in such a way as to imply that it might be, because it is not. Indeed, when it comes to the DC rules of professional conduct, when it comes to the Texas bar and their rules, when it comes to many states, rather than copying and pasting the model rule 1.7 language, those jurisdictions do a better job and they start the conversation. They start their version of Rule 1.7. It's 1.6 in Texas. They start their version of Rule 1.7 by stating out front, you can't bring a litigation claim against a current client. It should be stated that simply in the model rule. That certainly is the rule under the model rule, but the model rule is inartfully drafted. Other jurisdictions such as Texas, DC, and others, the drafting is far more artful. And it comes out and it just says point blank, you can't sue a current client. That's a rule. And you can't get a waiver to get around that rule. So a waiver is not available if you're litigating a claim against the client. It's also not available if prohibited by law. What do I mean by that? Well, in various jurisdictions, you'll find various statutes or rules that say that certain things can't be waived. Sometimes when you're in municipal law and a municipality, they're forbidden by statute or rule or sometimes a state constitution from waiving a particular conflict. There are other statutes, such as when it comes to former government employees and the ethics of returning to the private sector, having first worked in the public sector, where in certain jurisdictions, a waiver is not allowed. So that's the other thing you have to check for. You got to check the substantive law of your jurisdiction, because even the model rule acknowledges that if the substantive law of your jurisdiction says you can't have a waiver, then a waiver is not available. So a waiver is not available if it's litigating a claim against a client or prohibited by the law. It's also not available for a subjective reason of the lawyer who's seeking the waiver. If the lawyer has a reasonable belief that she'll be competent and diligent despite the conflict, then she can seek the waiver. But using a reasonable lawyer standard, we evaluate that lawyer's subjective belief. Now, the standard isn't all that high. Competent representation, diligent representation. Obviously, we had Model Rule 1.3 that talked about diligence, and we had Model Rule in Chapter 1 that talked about competence. Those things are always required. So if the lawyer believes those things can be maintained and the waiver is otherwise available, then it is also available to that lawyer in that instance. But available was just the first part of the inquiry. The second part of the inquiry was done correctly. If a writing confirms the affected client's informed consent, then the waiver has been done correctly. If a writing confirms the affected client's informed consent, then a waiver, if available, is done correctly. So basically, you, the lawyer who's seeking the waiver, you create a writing and you transmit it to the affected client after you, the lawyer, have provided adequate information to the affected client so that the affected client's consent reaches the level of informed consent. There's a lot there, including some surprising things that meet the Model Rule 1.0 definition of a writing, things that don't sound like writings at all. So let's break down this shorter sentence. If a writing confirms the affected client's consent in a lot more detail. To break down that highlighted portion, let's turn first to defining writing. A writing means anything given or transmitted to the client other than an unrecorded verbal utterance. And that is my paraphrase of that definition that appears in ABA Model Rule 1.0. Anything given or transmitted to the client. For example, an email. For example, a text message, SMS, Twitter, Facebook Messenger, FaceTime, a video, a handwritten note, etc., etc. If you look at that Model Rule 1.0 definition, it is so very broad as to encompass anything that can create that record that you can transmit to your client. What is excluded? Not much. About the only thing excluded are spoken words that you cannot retransmit to the client. Spoken words can qualify as long as you find a way to retransmit them to the client. Perhaps your smartphone, your cell phone, your iPhone, your Android phone has a record button, and you can take that WAV file or that clip of sound and send it over, send it back to the client. That'll count as a writing. So verbal utterances can meet this very broad Model Rule 1.0 definition of a writing, so long as you can retransmit them back to the affected client. But of course, we've put the cart before the horse. The writing comes second. What comes first? That the writing be from a client who makes informed consent. We won't forget to address informed consent. We'll address that in a moment. But before we do, we've got more to say about writing, specifically when in writing. And you know, there's some leeway under the model rules. There's some give. Look at why I say that. In my paraphrase, the writing can be given or transmitted to the client promptly. It's got to be given promptly, but promptly has some wiggle room. If that's not possible, then within any time that is reasonable under the circumstances. So, need it be immediate? No. Need it be contemporaneous? Maybe not, depending upon the circumstances. So, you've got to retransmit it. Say you're in trial. In the course of a trial, a conflict arises. Obviously, you've got to provide the informed consent, the information needed for the informed consent right then and there. But you can follow up later with the transmission of the writing that confirms the informed consent. It's got to be prompt, but that might mean within any reasonable time under those circumstances. You've got some leeway there under the model rules. So back to the horse that leads the cart. Back to informed consent. What is meant by informed consent? And what is meant, informed consent means with knowledge of the risks and the reasonably available alternatives. So there's two things that the client has to be informed about: risks and alternatives. All alternatives? Not necessarily so. Just the reasonably available alternatives. So the client has to be given knowledge of the risks and given knowledge of the reasonably available alternatives. Given by who? Given by you, dear lawyer. Given to the affected client by the lawyer who wishes to continue the representation despite the conflict. The model rule says that the lawyer must be the one who provides that knowledge. And it says so, not within Model Rule 1.7, but in that definitions rule, Model Rule 1.0. Model Rule 1.0 gives a definition of informed consent. And it's there that you can see in that definition that they're talking about you and me. They're talking about the client getting the informed consent from the lawyer who wishes to continue the representation despite the conflict. When's that a problem? Well, that's a problem when a duty of confidentiality prevents that lawyer from disclosing information that is necessary for that risk and those reasonably available alternatives to be conveyed by that lawyer to the client. Where a great unfairness arises under these model rules is where the client has the knowledge of the risks, has the knowledge of the reasonably available alternatives, but can't be reminded of those by the particular lawyer who wishes to continue the representation despite the conflict, because that particular lawyer owes a duty of loyalty or confidentiality that prevents that particular lawyer from repeating that information. That can sometimes happen. That results in a great unfairness, not only to the lawyer, but to the client too. And the model rules being so inartfully drafted don't carve out an exception for when the client already has the knowledge. So please check the enactment in your jurisdiction. Perhaps your jurisdiction were wiser than the drafters of the model rule. Perhaps your jurisdiction has such a carve-out. Another note, revoking consent. Remember those 4 concepts I talked about? The third of the 4 was that a client's situation can change. What if a waiver was available? And what if there was informed consent? And what if the client did waive? And what if you confirmed via something that meets the definition of a writing and you transmitted that writing to the client? Thereafter, is the client locked in forever? No. Thereafter, the client has the right to change her or his or its mind. A client who consents to a conflict may revoke that consent later. If so, then the lawyer must determine whether the revocation requires withdrawal. And we have a separate lecture about when a withdrawal is mandatory versus when a withdrawal is optional. So we will save the answer for another day, but we will highlight for today the fact that the withdrawal of the consent, the revocation of the consent, gives rise to that issue. Must the lawyer now withdraw? With those issues all on the table, let's end our discussion with some interesting case law precedent. We go back to the late 1970s. We go back to disco. We go back to bell bottoms. We go back to the Supreme Court of the United States with Chief Justice Burger. And we go back to the decision of Holloway versus Arkansas. Holloway versus Arkansas is worth putting on your reading glasses over, because it talks about so many of the issues that we've just gone over when it comes to conflicts of interest with current clients. Here in Holloway versus Arkansas, we had co-defendants in a criminal trial. It was the most egregious of crimes. It was not just an armed robbery of employees, but more than one of those employees were raped during the armed robbery, raped more than once for at least one of the victims. All the criminal defendants were assigned a single lawyer by the Arkansas court system. Of course, that means there's a potential conflict of interest, does there not? Anytime there are co-defendants who share a lawyer, there is the potential that those co-defendants might point fingers at one another and thereby cause a conflict of interest later, even if they're all in unison, even if they're all happily defended now. And indeed, that's what happened here. I think, although all of the co-defendants, reading between the lines of Holloway versus Arkansas and what facts are given to us by Justice Burger writing for the court, I'm thinking that although they were able to stay in unison and were able to be adequately defended when it came to the armed robbery of the business, where it may have fallen apart was when it came to the details of the crimes of rape. At least one of the defendants took the position that being upstairs and being the armed lookout somehow made that defendant less culpable for the rapes going on downstairs. We can't say with great certainty what exactly it was that led to the conflict because the facts don't give it to us, because the one and only joint lawyer struggled to share those with the trial court. And we see not once, not twice, even more than 3 times during the course of these proceedings, the one and only lawyer representing all defendants is attempting to express to the presiding trial judge the conflict. For over here, it mentions how there was a motion before September 4th for separate counsel. Later on September 4th, before the jury was impaneled, the attorney is renewing the motion for appointment of separate counsel. And the quote we have here is that it's on the grounds, quote, that 1 or 2 of the defendants may testify, and if they do, then I will not be able to cross-examine them because I have received confidential information from them, end quote. And the court seems to be hung up not on the confidential information. That's really important here. This one lawyer who's representing multiple defendants owes a duty of confidentiality to all of them. That's where the trial court should have hung its hat. But where the trial court seems to be hanging its hat instead is on the misuse of the phrase cross-examine, keeps saying or reminding or alleging to the one and only defense attorney that you don't cross-examine your own clients. But indeed, that's not an unfair description of what this one and only defense attorney is called upon to do in trying to defend one of the defendants against the finger pointing of the other defendants. So whether or not it was technically cross-examination or not, that shouldn't have been the focus of the trial judge. It's that duty of confidentiality. Remember, that was interfering under the model rules with the ability for this lawyer to be the messenger who delivers the news or reminds the client of the news when it comes to getting that waiver, and when it comes to making sure it's informed consent, when it comes to making sure they understand the risk and the reasonable alternatives. That duty of confidentiality to a current client or even a former client can interfere with the lawyer's ability to do that. Also, under the facts of Holloway versus Arkansas, eventually they did take the stand against the lawyer's advice, but it happened. First, the lawyer on the second day of trial, after prosecutors rested his case, is renewing for at least the 3rd time the motion to get his joint clients their own lawyers. And the attorney is advising the court that against his recommendation, all 3 defendants had decided to testify. And then here's the quote from what the one and only lawyer is saying to the presiding trial judge. Quote, now, since I have been appointed, I had previously filed a motion asking the court to appoint a separate attorney for each defendant because of a possible conflict of interest. This conflict will probably be now coming up since each one of them wants to testify, end quote. And the trial judge answers back, quote, that's all right. Let them testify. There is no conflict of interest. Every time I try more than one person in this court, each one blames it on the other one, quote. Maybe that's true, but the response from the one and only defense attorney was also true. He says, quote, I have talked to each one of these defendants, and I have talked to them individually, not collectively, end quote. And the judge, maybe being snide, just responds with, quote, now talk to them collectively. Justice Berger, in the opinion, then writes that the court then indicated satisfaction that each petitioner understood the nature and consequences of his right to testify on his own behalf, whereupon the defense attorney, Mr. Hall, observed, quote, I am in a position now where I am more or less muzzled as to any cross-examination, end quote. And with that correct observation, with that lament, and with that, if you will, renewal for the 5th time of the motion for separate counsel, The trial court answers as follows, quote, "You have no right to cross-examine your own witness." Again, the judge is hung up on the wrong thing, hanging his hat on the wrong issue, hung up on the potential misuse of the phrase cross-examination, forgetting about the duties of confidentiality, forgetting about the duties of loyalty, forgetting about the fact that there's a true conflict of interest here. The defense attorney responds to that "you have no right to cross-examine your own witness" response of the court by saying, "or to examine them." The court responds, "You have a right to examine them, but have no right to cross-examine them. The prosecuting attorney does that." The defense attorney responds, quote, "If one takes the stand, somebody needs to protect the other two's interest while that one is testifying, and I can't do that since I have talked to each one individually." The court responds, quote, "Well, you've talked to them, I assume, individually and collectively too. They all say they want to testify. I think it's perfectly all right for them to testify if they want to or not. It's their business. Each defendant says he wants to testify, and there will be no cross-examination of these witnesses, just a direct examination by you." And the one and only defense attorney responds, "Your Honor, I can't even put them on direct examination because if I ask them," at that point, the trial judge cuts him off. The court interposing says, quote, "You can just put them on the stand and tell the court that you've advised them of their rights and they want to testify. Then you tell the man to go ahead and relate what he wants to. That's all you need to do," quote. And of course, there was more that needed to be done, such as thorough examination, such as objections. Justice Berger quotes from the trial transcript, "At one point, it was so obvious that an objection needed to be made that the defense attorney couldn't make, that the criminal defendant himself, totally untrained in the law, no license to practice law, no legal training did this criminal defendant have, but the criminal defendant himself asks the court in the middle of the testimony if the criminal defendant himself can make an objection." But nevertheless, never did the court grant the motion for separate attorneys. And this was error. This was error to the point in this criminal justice case where the Sixth Amendment right to a fair trial and to the assistance of counsel that is adequate was violated. The court goes back in this 1976 decision to point out that more than 35 years ago in Glasser versus United States, 315 U.S. 60, 1942, this court, Supreme Court of the United States, held that by requiring an attorney to represent two co-defendants whose interests were in conflict, the district court had denied one of the defendants his Sixth Amendment right to the effective assistance of counsel. In that case, the government tried 5 co-defendants in a joint trial for conspiracy to defraud the United States. 2 of the defendants were represented initially by separate counsel. On the second day of trial, however, one of those 2 co-defendants became dissatisfied with his attorney and dismissed him. The district judge thereupon asked the remaining defendant's attorney if he would also represent another defendant. There were conflicts of interests. It couldn't be done. That happened in Glasser versus United States back in 1942, and the Sixth Amendment right to counsel was violated. It happened again 35 years later in this Holloway versus Arkansas. And yet again, the Sixth Amendment was implicated. So what we've got here are some important takeaways. What's the lesson? What is the takeaway of Holloway versus Arkansas? I can think of at least three that are noteworthy. First, a criminal conviction must be reversed if defense counsel is forced to represent multiple defendants, but counsel has a conflict of interest and objects on that ground. Second, requiring or permitting a single attorney to represent co-defendants is not per se violative of constitutional guarantees of ineffective assistance of counsel. And the third takeaway, in a case of joint representation of conflicting interests, the evil, it bears repeating, is in what the advocate finds himself compelled to refrain from doing. Look at the facts of Holloway versus Arkansas. There were confidences shared that the attorney had to refrain from telling his own co-client. There were questions to be asked of a witness that the counsel had to refrain from asking that would have benefited one of his co-clients. Remember the facts of Holloway versus Arkansas. One of the untrained co-defendants himself wanted to make the objection himself. It was that obvious an objection was necessary. Surely the attorney knew it, but the attorney didn't do it because the attorney couldn't do it because of the duties of loyalty, the duties of confidentiality owed to one client and not the other. The lawyer in Holloway versus Arkansas was right to ask again and again and again and again to please grant the motion for separate attorneys because it was needed, because there was a conflict of interest. And the facts of this case are relevant not just to the criminal law, lawyers out there listening, but to all lawyers, because it shows the importance of avoiding the conflicts of interest because of what's at stake. So there you have it, a hopefully helpful summary of the concepts that arise when there's a potential or an actual conflict of interest involving current clients. Next up, our next lecture, we will talk about these issues when it comes to former clients. And until that time, may God continue to bless us all. Thank you, each and every one of you, for joining me. I enjoy this. I hope it's informative to you. I hope it helps you in your studies and in your practice. Goodbye for now.